It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show. About to blow the bag, yo. Work. Hey, go and get that bonus. Work. Let me see your devotion. Work. You deserve the promotion. Work. Can't leave without that notice. Shout and make it right. Work that thing around the clock. Everybody came to see it. Got a line around the block. Cashing out the ones. I got funds and they never stop. DJ play a song. I'ma let them fly just like a fly. Ball status, drip it all platinum. Got a floss habit. Throw that money. Ain't no jaw jacking. I got more baggage. Show me some. I can change your life if you don't know what's up. Seen it from the front. Now back it up just like a loaded truck. Ay, I got plenty paper. I just wanna spend with you. Ay, I ain't got nowhere to be, so let me chill with you. Ay, you the prototype, the baddest one up in the room. I just wanna see you making move in your birthday soon. Ay, work. Hey, go and get that bonus. Work. Let me see your devotion. Work. You deserve the promotion. Work. Can't leave without that notice. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there this Sunday afternoon. We got to get into Tasha K and Cardi B once more, okay? Now, if y'all can remember earlier this year, Cardi B did come out on Spaces, and she let Tasha K know, I see what you've been out here doing. I see you talking about my family. I see you talking about things that are going on within a certain proximity to me. I've seen you out here still talking about me, whether you're saying my name or not. I want you to know that you're violating your agreed upon gag order that you signed off of when the court said that you owed me approximately $4 million. I've been letting you slide. I've been letting it go. But now, playtime is over, right? She warned Tasha K earlier this year that this day would come. And on Friday, the day came. Paperwork has been filed by Cardi B, reaching out to the court and the judge, seeking sanctions for violating the gag order and NDA that was put in place to where Tasha K could no longer talk about Cardi B, her family, her significant others, or anybody that's closely related to her. Tasha K has repeatedly continued to do so, and now her pockets may be ultimately affected even further. Despite being on a payment plan already with Cardi B, despite Cardi B coming out not too long ago seeking verification reports of her income to make sure that she's still making the proper payments to make sure that Cardi B is compensated for her hardships and the harassment that took place. But now, Tasha K most likely will be owing even more money on top of what she already is on the hook for. I don't know what it is with certain people in the media in these positions, especially somebody of Tasha K's visibility, right? Whether you want to call her a credible media source or what have you or not. Don't she got like 1 million plus subscribers? She has a lot of followers across different social media platforms. She has a large platform and just doesn't really seem to want to be responsible with it for whatever reason, you know? We see this same type of thing going on with the Milagros of the world as it pertains to Megan Thee Stallion. And we see that situation still has not been brought to an end. And Megan is still pursuing additional money from her. You would think at a certain point, especially these people who have these inflated egos, would feel like, ain't no way I'm gonna talk about you because you're not gonna be the bane of my existence across my platform forever. There's so many other
stories and things going on in the world that I could talk about. Fuck you, I'll skip. But again, sometimes speaking logic is just too simple. Okay, now let's get to the paperwork because there's quite a bit here, but they got facts, they have screenshots, they have everything that they need. They have evidence, and not only do they have evidence, but they're also seeking future sanctions because they believe that Tasha K is going to once again continue doing so, and they want to put a penalty ahead of time for when she does. This shit crazy. So here we are, United States Bankruptcy Court, Southern District of Florida, Fort Lauderdale Division. Of course, this is for Tasha K. Creditor Belcalis, Marlenis Almanzar's motion to enforce confirmed plan and confirmation order and to impose sanctions, including attorney's fees and costs. Creditor Belcalis Marlenis Almanzar, that is Cardi B, by and through undersigned counsel, hereby moves for entry for an order 1. Enforcing debtor's confirmed subchapter 5 plan of reorganization and the confirmation order, and 2. Awarding sanctions, including attorney's fees and costs in support thereof. Ms. Almanzar states as follows. This motion arises from a continued and unabated pattern of deliberate, calculated, and contumacious violations by debtor Latasha Transina Kibi of the non-disparagement provisions of her own confirmed subchapter 5 plan and the confirmation order provisions she negotiated, accepted, and agreed to as a condition of preserving her bankruptcy case. Okay? So what they're saying here is this non-disparagement provision was an agreement to not talk about Cardi or anyone associated with her. This is something that Tasha actually negotiated and asked for, and she can't even uphold her end of the bargain despite asking. The latest violation occurred just today, in less than an hour before this motion was filed. Since the plan was confirmed on March 4th, 2025, debtor has engaged in a relentless course of conduct designed to target and harass Ms. Almanzar and her family through thinly coded references, scantily veiled commentary, and strategic provocation, all while knowing that her audience of over 1 million social media followers will immediately and universally identify Ms. Almanzar as the subject. When caught, debtor belatedly removes the offending content only to repeat the same conduct days, weeks, or months later. Okay? So once Tasha gets her social media numbers, her engagement, whatever it is that she's fishing for, it gets to Cardi B's radar, her legal team. She tries to delete this stuff, thinking that it's actually doing something for her. And then she just continues the same behavior. Okay? Ms. Almanzar's counsel has been forced to issue no less than 3 formal written violation notices, monitor debtors' social media platforms on an ongoing basis, and expend substantial time and legal fees in a futile cat and mouse game that the debtor shows no sign of ending voluntarily. They've written her 3 times formally about violation notices, and Tasha has still not stopped. As she did the entirety of the underlying defamation case, and as she has done with respect to this bankruptcy proceeding, debtor believes she is above the law and is not required to follow the orders or admonitions of the court or comply with the terms of her own agreement. For example, in addition to the clear provisions of the non-disparagement provisions in the confirmation order, at the confirmation hearing, the court advised debtor, the court being the judge. And I don't know a lot about your business or what got you into this. All I'm going to say is to be careful. And this is an opportunity for you to, again, control how you deal with this problem, okay? And don't squander it, okay? You made promises, comply with them. And that will help you deal with this problem, okay? So I wish you luck. So this is A direct quote from the judge in the courtroom who said, hey, I don't really know everything about this situation that got you here. I really don't care. But you made promises. Concessions have been made. So stick to the rivers and lakes before Chile got to them, okay? I had to do it. Motherfucker said, I wish you luck. The court. So everybody, congratulations on getting it done. I know there's no trust. So what you have is an agreement. You have a contract. The judge acknowledged, I know you don't trust this motherfucker. You have a contract. Abide by it, okay? If everybody does what they're supposed to, this will get done. And Ms. Kibi, you will go a long way toward dealing with this problem again in a manner that you control and that is certain and that you know what you need to do, okay? But if there's an issue, I'm sure I'm going to hear about it. And you know, the consequences will be what they will be, okay? So again, the judge says, you have an agreement, you have a contract. These motherfuckers over here, they don't trust you not one lick. But since it's on paper and filed with the courts, this is how we're going to deal with it. So please handle it maturely and do what you're supposed to do. Because if you do not, I'm going to hear about it and I'm going to have to swing the hammer at your ass. Do you understand? Debtor's pattern of antagonism described herein makes clear she ignored the court's admonition. And what makes this pattern of defiance particularly egregious is not merely the violations themselves, but what debtor has openly admitted in public broadcasts, on multiple occasions in live streams, radio interviews, and social media posts viewed collectively by hundreds of thousands of people. Debtor has made unambiguous statements of her intent. She flouts the non-disparagement clause, and she has made clear that she intends to resume harassment of Ms. Almanzar once her debt is paid off. These are not the actions of someone who has inadvertently stumbled into violations. These are the actions of someone who agreed to a court-confirmed obligation under duress of dismissal, never intended to honor it in spirit, and is openly attempting to engineer a path around it. These are the actions of someone who has no respect for obligations she agreed to in the plan, the confirmation order, or this court. Importantly, the cure period of paragraph 14B of the confirmation order was designed for a singular, narrow, and specific purpose: to give debtor an opportunity to remove content about individuals she did not know were family members of Ms. Almanzar. It was never intended as a general license to post knowingly prohibited content, wait to be caught, remove it, and repeat. Debtor has weaponized the cure provision as a business model, post patently false, disparaging, and defamatory content about Ms. Almanzar and her family, generate tens of thousands of views and corresponding advertising revenue, then remove the post after receiving a notice, and after the damage is already done, the views are already collected, and the screenshots and reposts by other content creators have already amplified the harm beyond recall. Motherfuckers be weaponizing it, especially that Twitter shit. Man, something is going to be done about this Twitter shit. And I see some popular repost pages and stuff like that. They've been complaining these last couple of days because Twitter actually just revised their payment. So basically, if you're not an original creator on Twitter and you're getting by reposting stuff from podcasts or reposting other people's posts, trying to monetize off of it, their pay is getting significantly decreased, I believe, by 60%. And I think in the next week or so or next month, they're going to decrease that an additional 20%. So you're going to get an 80% decrease in your revenue. So clip farming and engagement farming and rage baiting using other people's content on Twitter is about to be eradicated. Otherwise, you're just going to be doing it for the love of the game because you're not going to be getting no money off it. They already don't be paying shit. And that money that they're taking from those creators is going to go to creators who are actually creating original content on the platform. So All of this is very interesting. Anyway, we'll keep going. This court has full authority and, respectfully, the obligation to put an end to this pattern. A confirmed plan is an order of this court. Violations of court orders have consequences. Ms. Almanzar respectfully submits that those consequences are long warranted and past overdue. We could go past the jurisdiction and venue part. That's not important to us. Now, here they get into the background of this situation. The plan, the confirmation order, and the non-disparagement clause. On March 4th, 2025, this court entered the confirmation order confirming debtor's third amended subchapter 5 plan of reorganization. Again, this is related to her bankruptcy. Because remember, when the judgment was filed, that was Tasha K's way of trying to circumvent having to pay. She tried to file bankruptcy to try to get around it. Cardi B and her legal team said, not so fast. You might be able to get around some of your other debts, but not this one. The court said, for sure. So now she's been on a payment plan, having to pay out of her YouTube monies, social media monies, any endorsements or partnership type of things that she has going on. Whatever her website money is bringing in, subscription money that people are paying her, all of that got to be bust down to Cardi B. Again, Cardi and her legal team just recently put an order or a motion into the court to say, hey, we need to have her finances rechecked. Okay? So they're not playing no fucking games. The plan and confirmation order are binding upon debtor and all creditors as orders of this court. Ms. Almanzar holds an allowed non-dischargeable defamation judgment in the amount of $3,911,680.95. Don't you forget it. Arising from debtor's sustained and malicious campaign of defamation against Ms. Almanzar, and as such, Ms. Almanzar alone comprises 98.28% of the entire unsecured creditor body. The defamation judgment was entered by the USDC for the Northern District of Georgia and is expressly accepted from discharge pursuant to paragraph 6 of the confirmation order. Accepted from discharge meaning this ain't going away. As a material condition of the plan, Ms. Almanzar agreed to a conditional injunction staying enforcement of the defamation judgment against debtor and certain non-debtor parties, including Shekinah Kebe, and Yellen Entertainment for the duration of the plan, but only so long as debtor remains in full compliance with the plan's terms and is not in uncured default. Okay? In exchange for this extraordinary protection, a stay of enforcement of a nearly $4 million non-dischargeable judgment, debtor accepted, among other obligations, the non-disparagement clause set forth in paragraph 14 of the confirmation order. That clause prohibits debtor and all related parties, including Shekinah Kebe and Yellen Entertainment, from publicly making, publishing, or communicating, whether directly or indirectly, any derogatory, disparaging, or defamatory statements, remarks, or comments about Ms. Almanzar, her family members, or any entities owned or controlled by Ms. Almanzar in any public forum or medium, including social media. Confirmation order, paragraph 14. Paragraph 14A of the confirmation order further provides that the debtor shall ensure that no content related to Ms. Almanzar and or her family, whether explicitly or implicitly, will be published or disseminated on any of the debtor's social media accounts, websites, blogs, or other online communication channels, including, without limitation, Unwind with Tasha K, the Wine Cellar Podcast, or Tasha K Live. Okay? All of her media entities. Paragraph 14B provides a narrow cure mechanism applicable only when a prohibited comment is made with respect to an unidentified Almanzar party that is a family member of Ms. Almanzar not known to debtor or the general public to be related to Ms. Almanzar. In that limited circumstance, Debtor has 48 hours from receipt of notice to remove the content. This cure provision was never intended and plainly does not apply to direct or indirect commentary about Ms. Almanzar herself or about individuals publicly and universally known to be her family members. So they're saying that Tasha K has been leaning on paragraph 14B, which gives her the opportunity, if by chance she happens to speak about a family member of Cardi B that she happens to not know is related. In that case, she has 48 hours from the receipt of notice, right, to say, hey, you did some commentary about this person. This person is related to Cardi. Please take it down. At that point, you have 48 hours to remove it. Rather than comply with those guidelines, Tasha K has then been talking shit about Cardi or around Cardi and using that 48-hour clause to say, hey, I got 48 hours, I can take it down. And they saying, we will not accept that. Okay? Paragraph 14C provides that failure to implement a timely cure to any violation within this provision shall constitute a material breach of the plan and may result in additional legal remedies sought by Ms. Almanzar, including without limitation the legal right to seek dismissal of debtor's bankruptcy case or conversion to a Chapter 7 of the Bankruptcy Code. So not only is she perhaps at the mercy of legal sanctions, but paragraph 14C says that Cardi B could possibly dismiss Tasha K's bankruptcy case altogether, where she would still be on the hook for all of her debts, period. Or they would convert it to another form of bankruptcy, Chapter 7. Now, I'm not a fucking bankruptcy specialist, so we'll continue. It is critical to understand the context in which the non-disparagement clause was agreed to prior to confirmation. Debtor's own counsel argued in court filings that Ms. Almanzar's proposed non-disparagement clause was so broad that it would undermine debtor's career, and that Ms. Almanzar was seeking to sabotage debtor's career through unreasonable restrictions on her First Amendment rights. Ms. Almanzar then withdrew her objection to confirmation of a plan in exchange for the non-disparagement clause being incorporated into the agreed plan. Debtor, through counsel, accepted these terms. She cannot now claim to be surprised by or opposed to obligations she voluntarily accepted as the price of preserving her bankruptcy protection. Okay? And Tasha has come out on numerous occasions saying that her First Amendment rights are being violated. And they're saying, ma'am, you openly consented. We had a whole court negotiation about the terms of this plan, and you agreed. We had many conversations about this, but now that everything has been sent through paperwork-wise and you're getting back to work, you saying fuck us and anybody who love us. So we're going to show you who's doing the fucking today. Okay? And as noted by the court at the hearing held on January 9, 2025, it was entirely reasonable for Ms. Almanzar to insist on the terms of a non-disparagement clause, and that such a clause did not shock the court's conscience, that a non-disparagement clause was not offensive to the court, and further observed. I briefly reviewed the non-disparagement language. I recognize the dispute over it. I take no view on it and of itself, other than from where I sit, given the context of this case. It seems an entirely reasonable ask for Mr. Moon's client, who hold a nearly $4 million non-dischargeable defamation judgment, to insist on the terms of a non-disparagement clause that is agreeable to his client. Mr. Van Horn, if your client thinks it's too broad or will interfere with her business, that's her right, okay? But I don't take issue with their insistence on one. So he say, feel how you want to feel, partner. But I ain't got no problem with it. Debtor's pattern of deliberate violations. Since the confirmation order was entered, debtor has engaged in no fewer than at least 25 documented and egregious violations of the non-disparagement clause, spanning multiple platforms and escalating in brazenness, notwithstanding no less than 3 formal written violation notices from Ms. Almanzar's counsel. The violations are described in detail below, so now we get into the evidence. Debtor's pattern of violations shares a consistent and deliberate structure. A. Post content that unmistakably references Ms. Almanzar and her family members using scarcely coded language, nicknames, or contextual cues her audience universally understands. B. Generate tens of thousands of views, comments, and advertising revenue. C. Remove the content only after receiving a violation notice from Ms. Almanzar's counsel. And D. Repeat. Debtor's removal of the post upon notice reflects her awareness that the content violates the confirmation order. The removal is not remediation, it is an admission that she has repeatedly posted prohibited content deliberately, calculated that the benefit outweighed the risk, and acted accordingly. Basically, so she could keep making money to try to pay her off, which I'm not sure where she stands in that payment plan. C. Specific violations of the non-disparagement clause of the confirmation order. So here, violation number 1. This goes back to July 8th and 9th of last year. On or about July 8, 2025, Debtor published a YouTube live stream available at the following link, which I won't click, in which at approximately the 11-minute 30-second mark, she made statements claiming that God is blessing her for Stefon Diggs in connection with Miss Almanzar having publicly disclosed her relationship with NFL player Stefon Diggs. The reference to Stefon Diggs, then widely reported to be dating Miss Almanzar, is an unmistakable reference to Miss Almanzar's personal romantic relationship in direct violation of paragraph 14 of the confirmation order. In the same live stream, Debtor also referred to spousal support proceedings involving Offset, Miss Almanzar's husband, who is expressly protected under the non-disparagement clause as Miss Almanzar's family member. On July 8, 2025, Debtor posted on her X account, which had accumulated 94,500 views, the following: Nikki handing the internet that biz today. Number 11, let her cook. The number 11 reference is a direct, transparent, and barely coded, but obvious reference to Miss Almanzar having been named the number 11 best female rapper of all time by Billboard magazine's staff, a widely covered event at the time. The post generated immediate responses from commenters that clearly understood number 11 referred to Miss Almanzar. For example, we getting stand pages tagged in this motherfucker. At Barty's Media commented, tagging Miss Almanzar's verified account directly, stating, I think she forgot about that lawsuit. So the stand page came in and let Cardi know, hey man, it's some shit afoot over here. The audience unambiguously understood who number 11 referred to. This constitutes a violation of paragraph 14A of the confirmation order. On or about July 9, 2025, Debtor posted additional content on her Instagram account, Unwind with Tasha K, one of the specific platforms identified by name in the confirmation order, again using number 11 as a coded reference to Miss Almanzar, referencing Miss Almanzar's then new single Outside and boasting, I was sued and my network's still up. The wino's still drinking. I'm on tour, brand deals, and making reasonable and extremely affordable PR payments for the next 5 years to cover all my debts. Debtor further declared she was starting a free speech union and exhorted her followers to stay the course on exposing this post as a deliberate and compound violation. It references Miss Almanzar and her music, mocks the court-ordered planned payments, and signals to Debtor's audience her continuing intent to target Miss Almanzar. The post characterization of court-ordered payments as extremely affordable is also directly relevant to concerns about the accuracy of Debtor's income disclosures under the plan that will be the subject of a separate motion to be filed immediately upon the completion of discovery into the Debtor's inaccurate and misleading quarterly post-confirmation reports and Debtor's apparent avoidance of the true-up requirements of the plan and confirmation orders. So they say she's also been submitting inaccurate income disclosures. while making money, still discussing Cardi B and not wanting to pay. I mean, this shit got a red nose just poking out the motherfucking page. On July 9, 2025, Ms. Almanzar's counsel sent the first violation notice to debtors' counsel via email marked importance high, identifying each of the above violations with specificity, quoting the applicable provisions of the confirmation order, and demanding removal within 24 hours. Debtors' counsel acknowledged the communication and indicated a willingness to address the violations with debtor. A true and correct copy of the correspondence related to the first violation notice is attached as Exhibit A. Now we get into number 2. And they're going to show actual screenshots of what it is that she posted. Violation number 2. On August 7th, 2025, debtor published the following post on her ex account, Unwind with Tasha, which received approximately 30,000 views. Oh, winos. An anonymous wino wine tip came in. Oh, girl, she big pregnant again and still married. The new dude got like 3 other babies on the way, including her baby. My peep saw her in the mall, going to F off on a nigga about other women, sending her DMs about being pregnant as well. Y'all guess who in the comments? Sip secretly, hashtag. Okay? While debtor did not name Ms. Almanzar in this post, she deliberately invited her followers to guess who in the comments using the hashtag Sip secretly, a device designed to circumvent the non-disparagement clause while achieving its exact prohibited effect. The comments on the post confirmed that debtor's audience universally and immediately identified Ms. Almanzar as the subject, with commenters tagging Ms. Almanzar's official account and explicitly naming her. And you got some stupid ass followers, because if you trying to circumvent the game, why would you tag the person? Wow. Stupidity's being rewarded the other way. Other commenters reference number 11, consistent with the thinly coded reference established in the prior round of violations. This guess who methodology is a deliberate attempt to launder the prohibited communication through her audience. Debtor does not need to name Ms. Almanzar herself when she knows her followers know exactly who she is talking about and will do it for her. This is precisely the type of indirect communication the confirmation order expressly prohibits. On August 8, 2025, Ms. Almanzar's counsel sent the second violation notice to debtor's counsel via email marked importance high, copying the Subchapter 5 trustee and the U.S. trustee. The second notice expressly stated, "Your client is not clever," in attempting to obscure the target of her commentary. Her intent is transparent, and her disregard for the court's admonition is apparent. The fact that we have not reached even 1/4 of the planned term without repeated violations speaks volumes about her unwillingness to comply. Counsel further warned, if this conduct continues, we will have no alternative but to seek immediate relief from Judge Grossman, including sanctions and, if warranted, conversion of this Subchapter 5 case. A true and correct copy of the correspondence related to the second violation is attached as Exhibit B. Now we get into number 3. Remember, it's 25 of these hoes on here. Violation number 3, February 20th and 21st, 2026. Offset multi-platform post. On or about February 20th, 2026, debtor published content on at least 5 separate platforms simultaneously. On X, 31,000 views, Facebook, Instagram, Threads, and TikTok. Concerning Offset, Ms. Almanzar's husband. The post, published as a paid advertisement bearing the branding of both debtor's channel and debtor's counsel, Van Horn Law Group. Oh, wow. So that's the law firm that she's been promoting on all her fucking posts, is the law group that actually represents her. So I guess she's trying to lead business their way to pay off them motherfucking fees that she can't pay to their asses neither. What the hell is going on? People not only getting surgeries for promo, but now they doing goddamn legal counsel for promo. The fuck going on out here? Anyway, let's keep it going. Caption stated, "Ooh, Offset seems to be having a time out with his new girlfriend and his ex-fling, aka Jade. Offset is Miss Almanzar's spouse and is expressly protected under the non-disparagement clause as one of her family members. This violation is not subtle or coded. It is a post about Miss Almanzar's husband on 5 platforms simultaneously published as a sponsored advertisement and in direct violation of the confirmation order. Critically, Offset was specifically discussed and identified by name during the negotiation of the non-disparagement clause before planned confirmation. There is therefore no colorable claim that debtor did not know content about Offset was prohibited, as Ms. Almanzar's counsel stated in the 3rd violation notice. Considering Offset was specifically discussed when the terms of the non-disparagement provisions were demanded and incorporated into the plan and order, there is no question that Ms. Keeby is deliberately violating the non-disparagement clause. On February 21st, 2026, Ms. Almanzar's counsel sent the 3rd violation notice, noting that the post appeared on multiple platforms and that the Van Horn Law Group branding visible in the advertisement was particularly galling. The 3rd notice stated unequivocally, "We are past the point of warning and will be seeking court intervention at this point." That will be Exhibit C. Then we get into violation number 4. The Morning Hustle radio interview. On or about February 27, 2026, Debtor appeared as a guest on The Morning Hustle, a nationally syndicated radio program, for an interview that was broadcast publicly and subsequently reported on by The Morning Hustle's own website and multiple other entertainment news outlets, including Hip Hop Wired. The interview, for which a verbatim transcript has been preserved, contains multiple distinct violations of the non-disparagement clause. So here they get into Offset commentary. They spoke about him at 3:08 to 3:18. They spoke about him again at 29:50 to 30:09. That's minutes into the program. And then again at 31:04 up until 31:15. So his name came up 3 different times in this interview. During the interview, Debtor discussed Offset, Ms. Almanzar's husband, who is expressly protected under the non-disparagement clause on multiple occasions and at length. She described contacting individuals she believed to be associated with Offset and asking them about his alleged sexual conduct and personal relationships. She recounted that Offset had previously sent her a cease and desist letter regarding her content about him, and then proceeded to republish the substance out of that content on a national broadcast. So Offset individually reached out to Tasha K with a cease and desist, and she chose to persist. She also discussed whether Offset was trying to win Miss Almanzar back and commented on Offset's domestic arrangements, all in the context of a discussion about Miss Almanzar's personal relationships. Critically, the radio host's own question, did Offset send that Valentine's Day gift to the person we will not mention? Confirmed on air that both the host and debtor understood that Miss Almanzar was the subject of the discussion. Ain't that L'Oreal show? The non-disparagement clause does not become inapplicable merely because a third party declines to name the protected individual. Recharacterization of the defamation judgment. Timestamps 442 to 621. The debtor publicly stated on a nationally broadcast radio program that she lost because she was broke, and that the length of your bread determines whether you can win or not. She further stated, with respect to Ms. Almanzar's documented emotional distress and suicidal ideation, to which Ms. Almanzar testified at trial and which the jury credited in awarding damages, if that was truly the case, then that was not my intention. This conditional phrasing is a public on-air expression of doubt about the truthfulness of Ms. Almanzar's trial testimony. The debtor's disingenuous and deliberately dishonest characterization of her defamation loss as a product of financial disadvantage, rather than debtor's intentional and admitted multi-year campaign to emotionally, physically, mentally, and financially harm Ms. Almanzar, is not merely a self-serving and false narrative. It is a highly offensive indirect attack on the legitimacy of Ms. Almanzar's judgment, the integrity of the jury's verdict, and the veracity of Ms. Almanzar's documented suffering. This constitutes indirect disparagement of Ms. Almanzar, prohibited by paragraph 14 of the confirmation order. So she said, I didn't lose because I should have. I lost because I didn't have the money to fight. Here we have another piece. Payment plan admission from 1459 to 1526. Dater stated publicly that she is trying to keep my payments low and is not working double to make them. Boasting, baby. Do I look like I'm struggling? I got a publicist here. I got a whole team of entourage that roll with me. No, we're good. I don't know what it is about people that find themselves in this situation and have this incessant need to come to the people and say, oh, you think I'm like, number one, in the last piece, you said you lost because you was broke. Then in another part of the conversation, you say, do I look like I'm broke? Hell no. Nah. We traveling. I got a whole entourage. They up under me. We good, baby. I got a publicist here. Lack of money where? But then you go and submit inaccurate pay information regarding your income. This statement is a direct admission that debtors' planned payments are being intentionally minimized and that her actual financial condition is materially better than the income projections embedded in the plan. This is directly relevant to Ms. Almanzar's pending discovery request and the Rule 2004 examination of debtor. People taking this fucking entertainment shit too far. It gotta be a time when you cut that shit off. Because if you can't, we gotta question your goddamn mental capacity. The statement, I'm trying to keep my payments low, is another direct admission that debtor is deliberately suppressing her reported disposable income to minimize planned payments to Ms. Almanzar. Her boast that she is quote unquote not struggling while maintaining a full team, publicist, and active touring schedule directly contradicts the misleading income projections embedded in the plan and raises serious questions about whether her quarterly operating reports accurately reflect her disposable income as required by the confirmation order. This is not merely a non-disparagement issue. It is evidence of a broader pattern of bad faith performance of the plan, which will be addressed in proper context in a separate motion with the court. So they gonna be doing a lot of motion on your ass. They gonna be doing a whole Macarena. They're gonna have whole choreography on your ass, and I ain't talking about the tour. They just gonna put a lot of motion in the courtroom. Damn. Undisclosed third-party funding disclosure. From 1617 to 1645, debtor publicly disclosed, apparently for the first time, that during the settlement negotiations that produced the confirmed plan, a third party identified as Now That's TV or Now TV offered to fund a $1.5 million lump sum settlement payment. Okay. So now they're getting into Now That's TV, who said, hey, we'll front $1.5 million to help pay off your debt, the nearly $4 million that she owes. My lawyer said I need $1.5 million. We went and got all the money. Shout out to Now That's TV, who put up the money. The debtor acknowledged this disclosure was sensitive, stating, you may get asked to cut this out after it airs. The existence, identity, and financial relationship of this third-party funder was never disclosed to the court or to Ms. Almanzar counsel during the bankruptcy proceedings and raises serious questions regarding undisclosed assets, income, and financial relationships that are directly relevant to debtor's plan, obligations, and the Rule 2004 examination. Now, the extent of her relationship with this Now That's TV network, perhaps they decide they were supposed to pay it off in exchange for her coming to their network to do content, produce shows or something. Who knows? I don't know if that ever materialized. But that's interesting. Stefan Diggs commentary 3139 to 3434. And all of this is from the same interview. Debtor discussed Ms. Almanzar's then romantic partner, Stefan Diggs, extensively and by name, including boasting that nobody would be talking about Stefan if it wasn't for me. So she takes complete credit for Stefan being a trending topic. Conducting what she described as a very intensive breakdown of Stefan Diggs, discussing alleged details about Diggs' personal life and associates, and reviewing the contents of a legal complaint filed against Diggs. She also interviewed the complainant. Debtor further stated she loved Stefan and expressed anticipation about his future projects, a demonstration of continuing active interest in generating content about Ms. Almanzar and her personal relationships. So here we get into violations number 5 through 20. Twitter post regarding Offset, April 10th, 2026. Debtor embarked on a sustained multi-day campaign of posts on her X account, targeting Offset, Ms. Almanzar's husband, and a party expressly protected under the non-disparagement clause. So this is last week. In connection with a widely publicized shooting incident involving Offset over the course of 5 consecutive days from April 6th through April 10th, Debtor published no fewer than 16 separate posts, when 16 ain't enough, specifically about Offset, his alleged assailant, his physical injuries, his personal activities at the time of the shooting, and related legal and personal proceedings. As established in connection with violation number 3, Offset was specifically discussed and identified by name during the negotiation of the non-disparagement clause. There is no colorable claim that Debtor did not know at the time she published each of the 16 posts described below that content about Offset was expressly prohibited. The posts are described in chronological order. So the first one, April 6th, Debtor published a post on her X account discussing him being shot. I'm not finna pull these up though. Violation number 6. Later the same day, Debtor published a second post on her X account discussing Offset being shot outside the Hard Rock Casino. Violation number 7. Debtor published a third post discussing Offset being shot and reporting that Offset was with Angela Stanton King at the time of the shooting, disclosing personal and circumstantial details about Ms. Almanzar's husband's whereabouts and companions. Violation number 8. Debtor published a post in which she stated that Offset wine is pouring and we're not missing a drop. A gleeful, self-congratulatory reference to Offset's shooting that makes unmistakably clear Debtor views her prohibited commentary about Ms. Almanzar's husband as content to be celebrated and savored by her audience. This post leaves no ambiguity about Debtor's intent or the identity of her subject. Violation 9. On April 7th, Debtor published a post discussing Offset's shooting and reporting on Lil TJ's alleged role in the incident. Number 10. On the 7th, Debtor published a post concerning Offset being shot and seen in a wheelchair following the shooting incident. So she's been following all of the chatter and the happenings around Offset's shooting, knowing that the non-disparagement clause specifically named him to not be spoken about at all. Violation number 11. Debtor published a post in which she reported that Lil TJ called Offset a rat and further referenced the Offset shooting. Violation number 12. Debtor published an additional post about the Offset shooting. Number 13. She published a post about Lil TJ shooting Offset. Number 14. Debtor published a post about the Offset shooting. This is Debtor's 7th consecutive post about Offset over 2 days, reflecting a sustained and deliberate editorial focus on Ms. Almanzar's husband that is irreconcilable with any claim of inadvertence or incidental coverage. Number 15. Debtor published a post discussing 6ix9ine trolling Offset in connection with the shooting incident. Number 16. Debtor published a post about Offset's facial injury sustained in his altercation with Lil TJ. Number 17. Debtor published a post about Offset being sued by a casino. Number 18. Debtor published a post about the Offset shooting again. Number 19. Published a post discussing Offset's court proceedings and legal winnings. Number 20. Less than an hour before the filing of this motion and notwithstanding the prior violations, violation notices, and dependency of this very proceeding, Debtor once again violated the non-disparagement clause by publishing a post on her X account engaging in gossip about the shooting of Offset. The frenzied and increased recent pace of violating posting on the part of Debtor reflects a level of calculated contempt for the confirmation order and this court that is beyond dispute. Debtor continues to violate the non-disparagement clause. Beyond the specific violations described above, Debtor has made a series of recent public statements and live streams, radio appearances, and social media posts that collectively and unambiguously demonstrate that her violations are willful, that she intends to continue targeting Ms. Almanzar, and that she views the non-disparagement clause as an obstacle to be overcome rather than an obligation to be honored. These statements constitute independent evidence of bad faith and are detailed below. So here we get into a GoFundMe campaign from March of this year. In early March, Didder launched a GoFundMe campaign out of spite with the stated goal of raising $3.5 million to pay down the defamation judgment expressly describing Ms. Almanzar as a creditor and the judgment as a judgment debt. While technically accurate, the campaign is designed to publicly frame and weaponize Ms. Almanzar as Didder's financial antagonist and to invite public sympathy and community mobilization in opposition to Ms. Almanzar. The campaign page states that Didder wants to close this chapter and move forward without constant legal distractions, and publicly characterizes Ms. Almanzar's legitimate enforcement of the confirmation order as an impediment to Didder's ability to focus on creating, reporting, and entertaining. This public campaign is itself an indirect communication about Ms. Almanzar, strictly prohibited by paragraph 14 of the confirmation order. The GoFundMe campaign is also directly relevant to debtors' income disclosure obligations under the plan. As of the date of this filing, the campaign has raised approximately $15,443 from hundreds of donors. Additionally, debtor has indicated she is also receiving funds through social media platforms like TikTok, Cash App, Venmo, a Kickstarter campaign, merchandise sales, and course offerings, all tied to the campaign around her judgment debt. It is unclear how much revenue has been raised so far, but this revenue must be disclosed in debtor's quarterly operating reports and accounted for in her plan payments, specifically the true-up provisions of the plan and confirmation order. Then we have X Spaces Audio from March 10th. In a recorded Spaces audio session, debtor publicly complained about being in chains as a result of the non-disparagement clause and expressed her desire to have her freedom of speech restored, making clear she is chomping at the bit to begin her harassment of Ms. Almanzar. This is a quote. "Play with me and play God. Watch me use God to clear this shit the fuck up. And then when I do, guess what? My freedom of speech is fucking restored. No NDA, no nothing. Then what's up? Oh, is that a 3-letter word? Is that a hoe? What's up? What's up? Ain't no chain. Ain't no chain. I asked God this weekend to break the chain. It's been 9 years." So she came out on some Mary shit here. Took the shackles off her feet so she could dance. "I'ma defame ya. I'm gonna defame ya." Ain't that about it? Then we have a Threads post. These statements are direct, on the record, admission that debtor understands and resents the non-disparagement clause, and that I don't know why that shit just hit me in my goddamn stomach off that Mary. I'm sorry. Damn! That her infrequent compliance is grudging and coerced rather than genuine. A debtor who genuinely intended to honor her obligations that she agreed to under a confirmed plan does not publicly lament them as chains. This audio, combined with the pattern of violations, demonstrates that debtor agreed to the non-disparagement clause purely as a tactical maneuver to preserve her bankruptcy case, not because she had any genuine intention of complying with it. And these statements make it clear that debtor has every intention of resuming the very same harassing and defamatory conduct that resulted in the $3.9 million judgment against her. Apparently, debtor still believes that she is above the law, consequences, and is invulnerable. This is a lot. Here we have a TikTok live stream thanking Nicki Minaj for donation on March 20th, my birthday, no less. I remember seeing this on online. On March 20th, debtor broadcast a TikTok live stream in which she publicly thanked Nicki Minaj for making a donation of approximately $3,000 to her GoFundMe campaign. Damn, that's it, huh? By publicly celebrating Miss Minaj's contribution in connection with the campaign to pay down Ms. Almanzar's judgment, on a live broadcast attended by tens of thousands of viewers, the debtor deliberately invoked the public's long-running fascination with an alleged but uncorroborated Minaj-Almanzar rivalry as a framing device for the event, with full knowledge that her audience would immediately understand the significance of Miss Minaj conspicuously donating to help the person who defamed Miss Almanzar. This conduct, orchestrating a public celebration of Miss Almanzar's purported rival, donating to offset Miss Almanzar's judgment, pun, constitutes indirect commentary about Miss Almanzar in direct violation of paragraph 14. During that same live stream, Debtor made the following unambiguous statements now widely reported verbatim across multiple mainstream outlets, including Complex, Gossip, and Hip Hop Wire. She says, I had a 15-year plan and I can keep it, but my freedom of speech is being affected and I don't like that. I got a big mouth and I gotta use it. It's way too much wine out here for me to be keeping anything from y'all. I keep y'all glasses full. I keep y'all thirsty. I remember playing this live stream audio last month. We're planning on being out of this bankruptcy in 1 year, baby. Argument. The court has authority to enforce the confirmation order. A confirmed Chapter 11 plan operates as a binding contract and a final order of the court. Bankruptcy courts retain inherent authority and express statutory authority under Section 105A of the Bankruptcy Code to enforce confirmed plans and to sanction parties who violate them. Section 105A provides that the court may issue any order, process, or judgment that is necessary or appropriate to carry out the provisions of this title. This authority expressly encompasses the power to enforce compliance with a confirmed plan and to impose sanctions, including monetary penalties and attorney's fees where a party's conduct undermines the plan's effectiveness. The confirmation order itself at paragraph 22D and F expressly reserves to this court jurisdiction to resolve disputes with respect to any and all injunctions created as a result of the confirmation of the plan and to enter such orders as the court deems necessary or appropriate with respect to enforcement of the plan. There is no jurisdictional impediment to the relief requested, and the judge warned her about this in person. Debtor is in material breach of the non-disparagement clause. The evidence set forth above irrefutably establishes that debtor has materially, knowingly, and repeatedly violated paragraph 14 of the confirmation order. Debtor has published at least 25 documented incidents of content regarding Ms. Almanzar or her family members across multiple platforms since the plan's confirmation. Used obvious yet thinly coded language, nicknames, number 11, old girl, and deliberate contextual framing to communicate prohibited content about Ms. Almanzar while maintaining plausible deniability about naming her directly while clearly naming her indirectly. Invited her audience to identify the target of her commentary, effectively crowdsourcing the prohibited communication. Published violative content across 5 simultaneous platforms in certain of the posts about Offset, including a paid advertisement bearing her counsel's law firm branding. Remove content only after receiving formal violation notices and after the views, advertising revenue, and viral amplification were already complete and the irreparable harm to Ms. Almanzar or her family members irrevocably done, and publicly admitted she resents the non-disparagement clause, views it as chains, and implies she will continue targeting Ms. Almanzar once her obligations terminate. We then get back into Tasha K's removal of posts, confirming willfulness, not compliance. Okay? And all of these things have been discussed before, so I really don't want to keep continuing to read the same shit. All right, so here we are at the conclusion. Wherefore, Ms. Almanzar respectfully requests that the court enter an order. 1. Requiring debtor to cease and desist immediately from all conduct in violation of the non-disparagement clause, including the direct, indirect, and thinly coded but obvious references to Ms. Almanzar and or her family members described herein. 2. Awarding Ms. Almanzar her attorney's fees and costs incurred in monitoring, documenting, and enforcing the non-disparagement clause from the date of the confirmation order through the conclusion of this motion and on a continuing basis for so long as monitoring is required. Because her legal team has been having to watch Tasha K's social media content. So they're constantly working on behalf of Cardi B, which then becomes a cost for Cardi because they're constantly watching Tasha K, documenting Tasha K, and sending notices to Tasha K for removal. So although she's trying to get her money from Tasha K, she's having to pay out even more money to her legal team just to try to get it. 3, imposing a prospective monetary sanction for each future violation. So this is where we get into the future violation of the non-disparagement clause, payable immediately to Ms. Almanzar in an amount the court deems appropriate as a deterrent, with the sanction attaching upon publication and not subject to mitigation by subsequent removal of the offending content. So she wants the judge to say, hey, you need to charge her X amount of dollars, which probably is not going to be a small sum, for any future violations that she may do of this clause, because she's already proven to us over 25 times the good faith is not good at all. We cannot trust her to comply with any of our guidelines that she negotiated and agreed to. Therefore, she need to pay me for all of those 25 posts violating the agreement, and she need to pay me future damages because I know she gonna do this shit again. And 4, granting such and other further relief as the court deems just and proper, including if debtor continues to violate the confirmation order following the entry of any enforcement order, dismissal of debtor's bankruptcy case pursuant to paragraph 14C of the confirmation order. It's some wild shit here. At this rate, Tasha K will be in a nursing home in 20 years, still figuring out how to pay this woman. She's still going to be going live, talking shit, forking over the cash, because she just cannot seem to break away from talking about Cardi B, Offset, Stephon Diggs. Out of all the celebrities out in the world, all the viral stories, all the big shit that's going on in the world, she just can't seem to break away from Cardi and her circle. Why? I don't personally know, but I guess that's probably what brings her the most engagement, because people like to see when she's antagonizing this situation purely for their entertainment, but she does it because their engagement produces finances for her. Unfortunately, those finances will be rerouted, and she admits that she's basically circumventing payments. So that's going to be even more issues for her to take in. Let me know what y'all think of this stupid ass shit down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. And before anyone does it, I want to just say, don't come over here talking about well, what is she supposed to do? Because I just detailed to you, there's so many other things going on to where she knows she don't have to talk about Cardi B, but she does it on purpose, and therefore she may have to just live with the consequences. That ain't got shit to do with me, ain't got shit to do with you. So just be careful before you start putting dumb shit in my comments, because I'm going to get with you. All right? Everybody else, I'll see y'all later. Much love and respect. Peace.
Yeah, family over fame in this bitch, yeah. The glory of living righteous is setting in. My street knowledge and education's a perfect blend. Young mogul, independent, I've been setting trends. The first one from my family to be faithfully wed. Fuck niggas and the horses that they riding on. I see this shit from all angles like a polygon. I'll never politic and the drama be piling on. Father and greats unacknowledged like I'm Bobby Bonds. Conversation with my lady about the paper route. 5 sit bank accounts every day I make it count. They down talking my commentary for hating now. Well, I can take it cause I'm bodying your favorite now, please. I can do this shit in my sleep. I been writing for these niggas, y'all read it and weep. I been fighting these niggas if you speak on the street. I'll turn your birthday party into New Year's Eve. Don't let me take it there. We ain't playing fair. This the ATL, Southside nigga. nigga moving furniture like Wayfair. Life on hold, no insurance for your healthcare. Lifeline gone, so you wanna be a millionaire? Well, let me tell you about this world I built. The women I dodged, the niggas that I ran for filth. The sympathy calls, consulting for the stacks I built.